One area of substantive law that a construction lawyer needs to have some walking around knowledge of is intellectual property, and that's going to be the subject of this video. So the main place where intellectual property issues are addressed in the AIA owner-architect agreement, in the case we're looking at, the B101, is in Article 7. And Article 7 starts off with a warranty by each party, the owner and the architect, basically that they've got the right to transmit whatever information they transmit to the other party. And so the concept there is that from the owner's standpoint, the architect's warranting, right, a warranty being a contractual obligation, so that if the architect breaches the warranty, the architect is in breach of the contract. The architect warrants that it owns the copyright to the instruments of service or any other information that it transmits. And likewise, the owner represents and warrants that any information it transmits to the architect, the owner has the right to transmit. That it is the copyright owner itself, or it has permission from the copyright owner to transmit the information. Because the owner and the architect are exchanging information on an ongoing basis. And so what 7.1 does is say, okay, each party actually has the right to transmit whatever information it's transmitting. And part of the significance of that is that if it turns out that a transmitting party doesn't really have the right to transmit the information, then it's in breach, and then it's going to be obligated to indemnify the receiving party as a result of any claims that may arise as a result of the transmitting party's breach of this warranty. Under the AIA documents, the main intellectual property issue is ownership of what's defined as the, quote, instruments of service. The AIA 201, which is the general conditions that are used in the design, bid, build, project delivery method, define instruments of service as essentially any creative work performed by the architect. And as you can see from the definition, it includes, without limitation, studies, surveys, models, sketches, etc. And so this is a very broad definition of any sort of creative work by the architect. That's what instruments of service are. So aside from the general obligation that each party has to ensure that it has the right to transmit information, more specifically, and what's really at issue in the negotiation of an owner-architect agreement, is who owns the instruments of service. That is, as we saw in the definition under the A201, essentially the creative work of the architect. And as you might imagine, from a document that's generated by the American Institute of Architects, the architect under this form agreement owns the instruments of service under section 2.2 of the B101. And that's pretty clear. Architect is the owner of the instruments of service, which, as we saw, is very broadly defined, and they include all common law rights, etc., as you see in the excerpt here in the slide. Now that's significant because ownership of the documents is important, both because there may be reasons why the architect has an interest in retaining this particular set, ownership of this particular set. For example, if it's essentially a cookie cutter kind of design that the architect has produced once and then reproduces on different projects for different owners, the architect obviously wants to make sure that it continues to own those plans and specifications, etc., because it's got a lot of sunk costs that aren't necessarily reflected in the fee that it's being paid on any single project. On the owner's side, particularly if this is a one-off project, a unique project, the owner may well want to own the instruments of service. The owner's position being effectively, we paid you to do this design, we should own it. And so this is often a point of negotiation between the owner and the architect, or whoever the design professional may be, whether it's an architect or an engineer. And who ends up owning the instruments of service, to some extent, depends on what fee is being paid to the architect. Essentially, if the owner is just paying a user fee to use the plans that the architect uses on other similar projects, chances are the architect will continue to own the instruments of service. On the other hand, if this is really a unique design that the architect's having to build from scratch and is getting compensated accordingly, it's reasonable for the owner to own those instruments of service. And the owner may indeed, depending on how unique the project is, may want to make sure that the architect doesn't take the design and tweak it a little bit and sell the design to another owner to build a very similar project. So if we're talking about a unique skyscraper, for example, that has a particular look that the owner is paying for, right? Think of the Wrigley building in Chicago, for example. The owner of the Wrigley building would presumably want to have that iconic structures design as part of its own portfolio of intellectual property, and would not want the architect simply reselling that design slightly tweaked to somebody else to build a competing Wrigley-looking building in downtown Chicago or any place else for that matter. Now, regardless of who ultimately owns the instruments of service, it's going to be clear that the owner has a legitimate right to have the right to use these instruments of service for example, ongoing maintenance or repair after the project's completed. These sometimes take the form of what's known as as-built drawings, but they can be a lot of the instruments of service, as we saw, is defined more broadly than simply the plans and specifications, the drawings. So the owner has a legitimate interest in having access to and being able to use the instruments of service on an ongoing basis, even after the architect's not on the scene any longer. And that's what 7.3 is about. 7.3 basically gives the owner a license from the architect to use the instruments of service for, as it says, constructing, maintaining, altering, adding to the project, etc., etc. And there are some strings attached to this that you can read in the fine print, but the basic concept is the architect, assuming the architect owns the instruments of service, the architect nevertheless licenses the instruments of service to the owner for use on this particular project. One situation that may arise is that the owner, having engaged an architect to come up with a design, subsequently doesn't use the architect for the construction phase, for example, or for some later renovation or remodeling of the project. And what 7.3.1 does is address that situation and says, in effect, that the owner releases the architect from any claims that might arise as a result of the owner's use of the instruments of service where the architect's not being used, right? Because the idea is that the architect, if the architect doesn't have any opportunity to clarify some aspect of the instruments of service in the construction phase, for example, where a contractor looks at a drawing, has a question, needs to ask the architect, but if the architect's not being used any longer on that project, only the architect's design that the owner has previously bought, the architect who made the original design doesn't have an opportunity to make that clarification that the contractor needs. And so the architect in 7.3.1 basically gets a release from the owner for any claims that may arise once the instruments of service leave the architect's hands. as a result of the owner's use of the instruments of service. But again, that's only where the owner is not then using the architect in connection with that use. Article 7 or Section 7.4 simply clarifies that the license that the architect's granting to the owner that we saw earlier is simply for this project, and the architect grants no other license, and the owner can't transfer the license to any other party without the prior written agreement of the architect. As you may remember from first-year contracts, generally contract rights are freely assignable unless the contract specifies that the contract rights are not assignable. Well, this contract specifies these rights under the license are not freely assignable without the prior written agreement of the architect. And then goes on to just sort of pile on by saying any unauthorized use are at the owner's sole risk and without liability to the architect, etc. So this is a good example of contractual provision preventing the assignment of contract rights. So this is something also that might well be negotiated in an owner-architect agreement, because the owner may have in mind that it's going to start this project, transfer ownership to some other entity, whether related to the owner or not, and want to be able to transfer the licenses that the owner has received from the architect for use of the instruments of service. So it's important to understand what this language about the owner shall not transfer any license granted hereunder may mean, depending on what the owner's plans for the project may be. Finally, Section 7.5 is what's known as a survival provision, and sometimes you see these at the end of the contract in very general terms. Sometimes you see them the way they are here, that are specific to a particular provision. But essentially what 7.5 says is that the provisions of Article 7, other than Section 7.3, survive termination of the agreement. And the reason this is important is that it's designed to clarify, okay, what we know that in any contract, right, performance comes to an end at some point when each party has done everything it's supposed to do. And at that point, the contract's terminated. Comes to its natural end because it's fully performed on both sides. The question sometimes arises, well, does that bring an end to every party's obligation under the contract? And what provisions like 7.5 are designed to do is to say, okay, some provisions, such as this one, ownership of the instruments of service, they continue beyond the termination of the agreement forever. And that's just to make clear that once the owner's done everything it's supposed to do under the contract, the architect's done what it's supposed to do, the architect continues to own the instruments of service unless this is a provision that's been changed in the negotiations. So this was just a brief overview of the intellectual property aspects of a construction project, particularly how they come out in the AIA documents. The main point here is that the chief form of intellectual property is the work of the architect, the creative work of the architect, which the AI provisions by default say belong to the architect. This is a subject that's often negotiated and depends really on the kind of project and the amount of money that's being paid to the architect for the design. So it's well to remember that the architect's going to own the design unless the owner changes through the negotiation of the B101 the ownership of these instruments of service.